Hi all, my name is Jason and I'm here to talk to you today about my guide to legal problem solving. The first part of the legal problem solving process is fact gathering. I emphasise the importance of understanding the client's needs when conducting this first step because if the information established is wrong from the start, then the legal problem will never be answered correctly. When conversing with a client, a lawyer should make the client feel as if they can trust the lawyer. There are several different methods the new lawyer points out that will help in the process of comforting the client and are listed on this slide. At the end of this meeting, a lawyer should have established the material facts and started to consider whether it is necessary to collaborate with other people to attain knowledge on a specific topic. It is also at this stage relevant that a lawyer knows the type of task that's going to be conducted. There are several different reasons a client may be seeking legal aid, and some are outlined on the wheel that is illustrated on the slide. They could be explaining and advising a particular course of action, negotiating with other clients or lawyers, advocating on behalf of the client, drafting documents, and so on. Once all this information is gathered, it may be necessary to ask the relationship between clients. If they have a good relationship prior to legal action, it could be a time to suggest other ways that the legal issue could be resolved. Often the legal process has a poor effect on the relationship of people in the dispute, and if there is an option that will allow both parties to be happy with the outcome and maintain the relationship, it may be worth suggesting. After this, if it is necessary to pursue legal action, it is time to consider the relevant area of the law. The figure on the slide shows the many different areas of law. It can sometimes be hard to categorise the problem into one specific area, and as a new lawyer, it will be even harder because experience will play a big factor when understanding the appropriate area of law. This means that it will be necessary to find statutes that are relevant and then do some background reading. Background reading is a great way to understand the purpose of a statute and will also help find the most appropriate ruling for a particular issue. It is from this process you start to see the purposive approach for statutory interpretation. To find the reason why a statute has been written, it is important to go onto the Australia Parliament House website and find the first writing of a bill. This will give the exact purpose of the law that has been created for, and it will make it very clear if it is relevant or not. Once the area of the law has been established, it is time to start researching for information that may be relatable to the legal issue that has arisen from the meeting with the client. Before any research can commence, it is important to have a plan on how the research will commence. The new lawyer has created an excellent table that I have placed on this slide. It gives 6 steps for planning the research, and the method of planning will need to be applied to each legal issue. After the planning stage has been completed, it is time to start looking for the law. There are many places online to find law, but it is important to ensure that any law being used is up to date. In the appendix area of my guide and on the current slide, I have placed a table of where to find information. It also notes what the sites are most useful for and has a link to each website. Again, many statutes may be hard to understand as a new lawyer, however we have been fortunate enough to be provided with a guide called Halsbury's Law of Australia. This guide is part of a secondary source, but it has all legislation with commentary to help develop a better understanding of the law. These secondary sources often reference case law, which is a primary source, and can be used as a precedent when constructing an argument. If dealing with a matter in court, a previous decision from a higher court, if the matter is relevant, will overrule a judge's decision, thus deeming relevant case law a highly important factor when finding research so you can apply it to a particular rule. Once a lawyer has sifted through all the databases and found relevant sources via a light reading, it is time to start doing thorough research. The slide presented shows the steps I take to research each bit of information. I then create a table for each research article which states the case citation, summary, key issues, main arguments, and the case's decision. After the research process is finished, it is then time to apply the research to the issue. This will create the body of the article for the legal problem. It is at this stage that statutory interpretation can be used to help find loopholes in a particular scenario, or even just help prove the points that you have raised about the client's particular legal issues. There are many ways an interpretation of a statute can be argued, and they are listed on this current slide. Once all legal problems have been created into separate summaries quoting legislation, case law, and any other information deemed relevant, it is time to create a document to present to the client, a case to represent in court, and so on. When creating these documents, the CIRAC method of legal writing is a great way to present the writing and is the method that is shown on the current slide. It starts by stating a conclusion. This is a necessary step to take because when in lower courts where traffic is busy, one may be hurried to relay information, so stating the conclusion first will ensure the important information has been obtained. You then point out the material facts followed by the legal issue and combine that information together to answer the legal problem. At the end of this writing, you restate the conclusion to emphasise the preferred outcome. It is important once the legal problem has been answered that you look over the information and critically evaluate the points that have been put forward. If when doing this process, you find the cons outweigh the pros of the argument, it will be necessary to restart the process for that particular problem until the pros outweigh the cons. This concludes my discussion about my guide. I hope this guide has helped provide a strategic method for answering legal questions for anyone viewing. My name is Jason, and I hope you enjoyed this presentation.